Good evening. My name is Kristen Ike. I am the Code Enforcement Special Magistrate for the City of Deltona, and I'm calling the Special Magistrate hearing of August 28th, 2024 to order. The first thing on the agenda is the roll call, so I will have all the code enforcement officers introduce themselves.
Mark Gibson, Code Compliance Supervisor.
Danny Raw, Code Compliance Manager.
Sharon Shivers, Fire Marshal.
Jory Bailey, Fire Inspector.
Lisa Nadeau, Fire Inspector.
Jessica Cotterman, Hearing Clerk.
Renee Kearney, Building and Code Administrative Supervisor.
Brianna Ron, Customer Service Representative.
Larry Spalding, Code Compliance Officer. Steve Rockout, Code Compliance Officer. Code Compliance Supervisor.
Janice Valesa, Code Compliance Officer.
Bashir Jersey, Code Compliance Officer.
Nicholas Lopez, Code Compliance Officer.
Okay, please stand and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Next on the agenda is my statement about how the hearing is going to run this evening, and I'm going to read this statement so I don't forget anything. We are here tonight because the City of Deltona has contended that there are violations of the Deltona City Code that exist. This is a public meeting, which means that no general public comment will be accepted, but each of the respondents and the code enforcement officers here tonight, and any witnesses each of you call, will be able to present evidence to me regarding each case and the violations of the Deltona City Code that are being alleged. I am an attorney and appointed by the City Commission to render decisions in these code enforcement cases to determine if a violation of the city code exists and what fine will be imposed, if any. If you are here for a Massey case, you might see that next to your case number on the agenda. That means that I will be determining solely whether you have come into compliance in a timely manner in accordance with the previous order the special magistrate issued in your case, and will not be reopening the case to determine whether or not a violation existed in the first place. Any decision I make this evening will be put into a written format in the form of an order. A copy of my written order will be provided to the city and then mailed to you as well. It is important to note that for any order I issue, you may appeal by sending a written notice of appeal to the Circuit Court within 30 days of the execution of my order, pursuant to Florida Statutes Section 162.11. The procedure of the hearings today will be governed by Chapter 162 Florida Statutes. Formal rules of evidence shall not apply, but fundamental due process shall be observed and shall govern the proceedings. Hearsay is admissible, but only to support other competent and substantial evidence. If you are a respondent, you will be able to testify. Tell me what you think I need to know about your case, present evidence and witnesses. Your testimony will be under oath, so I will be swearing you in, and this hearing is being recorded. For each case, I will call the case number and the city will proceed first. The city has the burden of proving that the code violation exists. Then you will be allowed to respond. For each case, I intend to admit the case file, and you should have received a copy of that file when you signed in this evening. If you did not receive a copy, please let me know when you come up. And I intend to admit that case file unless a specific objection is received. I will take the cases in the order that you signed in, first come, first served. I do not have any ex parte communications to disclose. And do I have, yes, I have a couple of cases to announce that have been withdrawn or continued. So the following cases have been continued. Fire 24-0037, a Massey case for 3000 Lake Helen Osteen Road. Fire 24-0045, 530 Bell Tower Avenue. DEL 24-078, 2301 Lake Helen Osteen Road. and 24079, 2301 Lake Helen Osteen Road. Those cases have been continued. So and then let me read the withdrawn ones. These are DEL 24-065, a Massey case for 2121 Capri Circle. DEL 24-073, 1420 Dressel Terrace. DEL 24-084 for 3000 Lake Helen Osteen Road, and DEL 24-086, 986 Sweetbriar Drive. So if you're here for any of those cases that I just read, you do not need to stay. It's either been withdrawn or continued to the next hearing. I will go ahead and swear in everyone who intends to testify today as a group, which includes the code enforcement officers. So if you intend to speak to me tonight, will you please stand if you're able and raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth? If so, please say I do. I do. All right, thank you. All right. I believe we will go ahead and get started with the cases. Okay, thank you. All right, first case is Fire 24-0043, 1870 Providence Boulevard, Suite 8A, B, and C. Good evening.
For the record, my name is George Bailey. I am an employee of the city of Deltona as a fire inspector. I'm sorry, it wasn't on. This would be case number Fire 043-2024, the city of Deltona versus 1870 Providence Suite A, B, and C, LLC. The property address is 1870 Providence Boulevard, Unit C, Deltona, Florida 32725. Parcel ID is 81306516030. This is a violation of the City of Deltona Ordinance, Chapter 42, Article 4, Fire Code, Chapter 42 through 186, which adopts the most recent edition of the Florida Fire Prevention Code as adopted by the State Fire Marshal, NFPA 1, Chapter 1.7.12.10. No construction work shall proceed until the ASJ has reviewed the plans for compliance with the appropriate codes and standards and the appropriate permits have been issued. Corrective action for said violation is to obtain a building permit for the interior walls and the door. The statutory requirements for notification of this hearing has been met by the notice of the hearing, and notice of code violations were sent certified mail to the property owner at the address listed with the property appraiser record. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All the evidence in this case, including the photographs, have been marked as exhibits and submitted to the Special Magistrate Clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. On March 26, 2024, while conducting a fire inspection, I observed a wall and door constructed in the interior of the suite leading to the rear egress door. Upon further research, I was not able to locate a permit for the construction of this wall and door. Subsequent inspections on May 22, 2024, June 20, 2024, and July 8, 2024 found the wall still in place with no permits issued. The city would like to request 60 days for the property to come into compliance or a fine of $50 per day until such time that the property owner has notified the city of compliance.
Okay, and you said 30 days?
60 days.
60 days, okay. And $50 per day was your, okay?
Yes, ma'am.
And so the wall that was constructed is the one that we're looking at in this picture with the reading room door?
Yes.
Okay, and then what's behind that?
Behind that door is like I believe like a reading room where they can read, like, I guess, cards and palms and so on.
Okay, all right. Is the property owner here?
Yes.
Okay, would you like to come forward? Can you state your name and address for the record?
Gabriel Fernandez, 1870 Providence Boulevard.
Okay. Yes, can you speak a little closer to the mic?
Okay.
I don't know if it's, make sure it's on.
Okay, I'm here because I didn't know, when I bought the property, that wall was there. So that wall might be there, maybe older than Mr. Bailey. So I didn't never know it was illegal or somebody put it there illegal. So I'm just here to do what I have to do to fix the problem.
Sure. So, and I think what you're asking is that a building permit be obtained for the wall,
Either a
correct?
building permit is pulled to for the wall, or you can take it down. If you take the wall down, you will not require any permits to return it back to the original state.
Okay.
Okay. So, like I said, so what my role here is to make sure that I give you a time to comply. And if you don't comply by that time, though, a fine would be imposed after that. But we do give you some time to comply. So, and in this case, the city is asked for 60 days. So you would have 60 days to either decide whether you're going to get your permit and obtain that or take the wall down.
Okay.
Okay?
I'm fine
All right,
with
is there
that.
anything else you'd like to add, sir?
No.
Okay. All right. I'm going to find the respondent in this case in violation of the city code as charged, and that respondent correct the violation before 4:00 p.m. on, I'm going to say it's actually 61 days, so it's not on a weekend. So that would be Monday, October 28th, 2024.
Okay.
And in the event respondent does not comply by this date, a fine in the amount of $50 per day will be imposed for each day the violation continues past the aforestated date. Respondent is further ordered to contact the code inspector to verify compliance with this order. So please make sure you stay in contact with him.
Okay.
Okay? Thank
No
you.
problem. Thank you.
Okay, the next case is 24-077, 2961 Harper Street.
That one I requested actually removed. That one, and there's two cases for Harper that come into compliance. I sent an email, might not have gotten it.
Okay, all right, so,
Yes.
okay, so we're going to withdraw this?
Yes, please.
Okay. So I'm sure you can go out in the hallway and talk with him, but I'm going to we'll withdraw this from the agenda. Hang on one second. Wait, what was it, the number? 24? 077. You can try. Okay. All right, next case is 24-0042, 1565 Saxon Boulevard, Suite 301.
Ma'am, what was that number again?
Fire 24-0042, 1565 Saxon Boulevard.
The inspector is currently talking to the previous case.
Well, why don't we,
Let's move on to the next one. Yeah, we'll take the next one.
okay, yeah, let's do the next one. And then we'll come right back to that one. Okay, this one is DEL 24-019, a Massey case, 2500 Leonard Drive. Good evening.
Okay. My name is Todd Mead. I'm employed by the City of Deltona as a code compliance officer. This will be Massey case number DEL 24019 Massey. The City of Deltona versus Emmanuel Elysia and Verez Karaznazik. The property address is 2500 Leonard Drive, Deltona, Florida 32725. The parcel ID number is 810-900-000-120. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation sent certified mail to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted at the City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the Special Magistrate Clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. It was ruled on February 28th of 2024 that the property owner was given 120 days to comply. The owner did not come into compliance within those 120 days and has been receiving a fine of $25 a day since June 29th of 2024. As of today, the property has accrued a total fine of $1,525 over 61 days. The city is requesting that these fines continue at $25 per day.
Okay. So can you remind me
Okay, this was a property at the end of Leonard Drive, and there was a Connex temporary storage structure on the property that was noted as it's not allowed in the city of Deltona. So we gave the property owner time to either remove it or within the 120 days. And I think in his last, I took over from the last other officer, but I believe he also had suggested he was going to sell the property as well at that time. So he was given the 120 days to try to comply with the removal or the sale of the property where it would continue on with another owner if it was sold.
I believe I recall now, correct me if I'm wrong, that you previously testified that it was very difficult to try to move?
Yes, ma'am.
And, okay. All right. Mr. Mead, do you have anything else you wanted to add?
Oh, that's it, is it?
Okay. All right. Can you state your name and address for the record?
Yes, Bezira Krasnici, 1821 South Houston Drive, Deltona, Florida, 32738.
Okay. What would you like to tell me about the case?
Yes, ma'am. We actually bought the property that was already accumulated with debris in there, abandoned vehicles, boats, and so forth. When we purchased the property, obviously the Connex was there, which I've done some research on my own, which was previously presented, that the Connex had been in place since probably 2017 or 2018. I do believe that on the 28th of February, my husband was here, and he stated that we were going to take care of this and try to remove it. We've had potential buyers, but obviously due to the road access and the easement that we have, and we're dealing with that problem, the people are backing off on the deal and they're not buying it. I don't have the financial resources, obviously, to hire someone and lift it. The Connex is massive. Like I said, we've bought it and we've inherited the problem. And the problem obviously had not been, there had not been no complaints until we bought the property. I had personally had gone there to place the box in there when we listed for sale, and I had neighbors that they had come in and jokingly had said that, how do you like those hefty fines? So apparently I feel like this is more of a personal versus a violations, because like I said, I'm a lawful citizen. I try to obey the law and do my best as a United States citizen, but at the same time I feel like the Connex had been there. We've inherited a problem. We are trying. I don't believe that 15, I respect the city rules and laws, but at the same time, I cannot afford to pay these fines as I'm trying to make a living and pay my mortgage at the same time. I bought this property in hopes that I would invest something. The business didn't do very well, so I'm trying to recover from this hard situation that we're all going through it. It's been a nightmare. This is like, it's really a burden that, I have that Connex in there, but I feel like it's not really right to be paying fees or fines for something that was there before I had bought it, and nothing, no issue, no complaint or nothing of that nature had been filed beforehand. So obviously I will leave it up to you to make a decision whether, you will impose the fine or not, but I do need time. I don't have the financial resources, like I said, and I do need time for someone to just come and get it, even for free. So I just don't know what to do with it.
Yes, sir. Can you state your name and address as well?
Emmanuel Isaiah, 1821 South Houston Drive, Deltona, Florida, 3273. Man, even if we were to find somebody to pick it up for free, in the beginning of the road, if you go back to the picture with the gates at, there's been issues that between myself, the city, and the neighbor because of where the median goes down. They have placed a permanent structure there in the middle of the median, okay, the access. I filed a complaint to find out why there was in the middle there, because it's going to stop a tractor trailer or someone, whoever's going to come pick the trailer up, is going to stop them from making that turn with that big trailer. And I filed a complaint to see the proper information to see where the permit's at for the permanent structure, and when did it get approved to be in the middle of that East Bend Road, and it has been closed twice, and nobody wants to give me answers. I know it's a permanent structure. I mean, it's in the middle of the road, and it's not supposed to be there. So the property was vacant for like 8 years before we bought it. The neighbors next door that put that structure there, I've only been there for the past 6 years. So I'm being told that, it's probably got lost in the old records. Well, it's only been 6 years since the neighbor moved into the house. The old records were back in 2000, the early 2000s, something like that. So I'm still trying to figure out why is that permitted there, because it's splitting my entrance and my neighbor's entrance. But at the same time, he took 20 feet away from me from my entrance when he did that. So it's back and forth. Who's right? Who's wrong? Who gave the permission for that permanent structure? And every time I apply for that request, I get denied or it gets closed. I've been up here many times to speak to Mr. Carl about the situation.
So you're
And I
saying
don't
you
get no-
file a complaint with the city?
Correct. And it's got nowhere. But then we tried to do the right thing, clear this place up when we bought it, and try to make things look good in that neighborhood. And here we are getting punished for trying to do the right thing. I mean, this place was a mess. You couldn't even see nothing in this place. Okay, this place, there was no road there. There was nothing there. Abandoned boats, abandoned cars. We pulled everything out of there, trying to make everything look good. And then we feel like we're just getting targeted and punished for no reason. I mean, if the Connex is really bothering the city of Deltona, feel free to pick it up any day. Because we don't need it. We just can't figure out how to get it out of there.
Yeah, I'm sorry. So are you saying that it would not be possible for a truck to come in to get it, get the box because of
the radius
whatever?
is not there.
I'm sorry?
I don't believe the radius for the truck to pull that long container is not there because of that permanent structure that was set in the middle to split both property entrance.
Okay.
That shouldn't be there because there should be 20 feet back. And again, I requested permits for that and his fence line. There's nobody wants to show that he had permits for that. They show permits that he pulled permits to put a fence up, but no permanent structure column. And he had some automatic gate. There's also no paperwork for the electrical in that gate. There's no permits also pulled. So I asked for that request. I found all this information out, but then we getting punished for this when everybody is going to be in violation if we come to it. I don't want to be there. I don't want to be that guy. Simply, I don't even want to be here today. If you guys want to take that Conex out of there, feel free to do it, but we don't have the options to owe the money to get it out of there.
Okay. Well, I guess, as I previously ruled that, this was a violation of the code, I understand the difficulties that you're having. However, I provided, I believe, 120 days, correct, for compliance, which is much longer than we typically, or that I typically allow. And so while I recognize you're having a lot of issues, unfortunately, we've already provided quite a lot of time for this to be corrected. So I am going to find that, you haven't come into compliance. The only thing that I'll add is that if, once you are able to get it corrected, you may be able to come back to the city and request a lien reduction. And you can speak to Mr. Ron about that. However, that requires you to actually come into compliance before you do that. So I'm gonna go. Did you have something you wanted to add briefly?
I disagree with this because, again, in order for this to take place, somebody had to file a complaint, correct? Where's that complaint? We still haven't seen nobody's complaint. We paid for a fee to pull a complaint to see if there was this matter, but it had to do with the chicken and roosters that we had loose. So where does this come about? How did this start? Who came in my property and took these pictures? Because we didn't allow nobody. Everything is fenced in. So if we're going to proceed with this violation, then I want to know where's that report, who made it, and who went in my property and took these pictures. It's just not right. We're getting violated everywhere.
Yeah, maybe when I can't officially say that's what it will happen, but when we went there for the initial complaint with the chickens and roosters, that's when the officer probably noticed, I think there was vehicles also on the property. This is a vacant property and no structure is supposed to be on there. The only thing we allow is a fence with a permit, and maybe that's how it got initiated when it comes to the kind of stuff.
I understand that, but again, it was not reported as a violation of somebody or neighbors being bothered by it. So you went there for one violation, noticed something that could have been a violation, investigated it, but it's been there from the past. We bought it. You gonna make me pay for someone else's mistake or law that they broke, and I bought this intentionally, not knowing nothing at all, trying to make things right and clear things around the neighborhood, but I'm getting penalized? I think I deserve a chance to hire me an attorney if needed, because I don't think it's right.
Okay.
I don't think it's right. I think there's a violation somewhere coming on you guys' end, because enforcing the rule is one thing, but trying to find somebody guilty of something they're not, it's a different story.
I mean, once you become a property owner, anything happened prior to that, you pretty much take responsibility for everything that's happened on that property, and that's how this situation probably happened.
I'm pretty sure there has to be a way, sir, to start from the beginning of this. Who put in the request? Who made the complaint? Without a complaint, you can't start a case. That's to my knowledge. You can't take me to court if I'm driving down the road without a violation or without a case, somebody or officer making a report or something of that nature.
Mr. Mead, do you have any information about how the case was originated?
The officer's initial notes, went to the property to investigate the animals and did notice that the fence was there and the Connex box, and that created
Right.
to create the second violation, which was the Connex box.
Right. So, code enforcement officers are able to go to a property and, visually inspect what's going on. They don't have to have a complaint from a neighbor to initiate a case. So I'm gonna move on. I think that we've gone over your arguments. I'm going to find that respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order, and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code inspector. Respondent shall notify the code inspector to verify compliance. So please make sure you stay in contact with Mr. Mead and let him know.
Get in contact with you guys.
I'm sorry?
I will have my attorney contact you guys, remind this case. This is not right. I'm not accepting these violations, and I'm not going to pay because I don't have the money at the moment. And I'm going to try to make sell something if I have to get an attorney, because I'd rather pay the money towards an attorney than towards something that I have not violated or committed any crime or broken any laws. I have not broken any laws here. I bought a property. I bought it single.
Well, I've ruled otherwise, and but like I said, you're certainly, as I said at the beginning, my order can be appealed, and I explained that at the beginning. So we're going to move on. Thank you.
Yeah.
All right, so we'll go back to case Fire 24-0042, 1565 Saxon Boulevard, Suite 301. Go ahead.
All right. For the record, my name is Jory Bailey. I am an employee of the City of Deltona as a fire safety inspector. This will be case number Fire 042-2024, the City of Deltona versus Medical Building LLC. The property address is 301-1565 Saxon Boulevard, Deltona, Florida 32725. Parcel ID is 812-003-003-010. This is a violation of City of Deltona Ordinance, Chapter 42, Article 4, Fire Codes, Chapter 442-186, which adopts the most recent edition of the Florida Fire Prevention Code as adopted by the State Fire Marshal, NFPA 1, Chapter 1.7.12.10. No construction work shall proceed until the AHJ has reviewed the plans for compliance with the appropriate codes and standards and appropriate permits have been issued. The violation of NFPA 1, Chapter 13.7.1.1 mentions in the notice of violation has been resolved prior to this hearing. Corrective action for said violation is to obtain a building permit for the newly constructed employee break room and restroom and associated plumbing, electrical, and mechanical work. The statutory requirements for notification of this hearing has been met by the notice of hearing, and notice of code violations were sent certified mail to the property owner at the address listed with the property appraiser record. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the Special Magistrate Clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. On November 3rd, 2023, while conducting a fire safety inspection at this location, amongst other violations which has since been resolved, I observed what appears to be newly constructed walls and electrical inside of an employee break room. In addition to a newly installed washer and dryer with associated plumbing and mechanical. In addition, I observed a newly constructed door opening leading to a bathroom with relocated plumbing for a sink. Upon reviewing the original approved building plans for this location, it was determined the area now being used as an employee break room was originally permitted as a women's locker room with access to the bathroom through the locker room, which was now walled off and accessed through the newly installed opening. In addition, the washer and dryer was not part of the original building plan. Subsequent inspections on December 28, 2023, February 29, 2024, May 2nd, 2024, and June 17, 2024 found a non-permitted interior alteration still in place. Permit BLDC 24-0009 was applied for on January 18, 2024, and subsequently denied due to being insufficient submittal on January 25th, 2024. A secondary response was submitted on August 20th, 2024, but was also denied due to being an insufficient submittal on August 25th, 2024. The city would like to request 60 days for the property to come into compliance with the remainder of the violations or fine for $50 per day until such time that the property owner has notified the city of compliance.
Okay. And so when you say $50, are you saying $50 for each violation here or $25 each?
At the moment, it's only one violation, so it's $50 per for the.
Okay, so you're saying is 13.7.1.1, has that been corrected?
Yes, ma'am. That was for a fire alarm.
Okay.
They did get a permit for that, and it has passed inspection.
Okay, so we're only dealing with 1.7.12.10.
Yes, ma'am.
All right, thank you. And this is the permit that you said was denied twice?
Yes, ma'am.
All right. Did you have anything else to add?
No.
All right. Can you state your name and address for the record, please?
Yes, ma'am. My name is Mark Tracy. I'm one of the owners and the managing member and landlord of Medical Building LLC. The first point that we need to clarify is Medical Building did not do any modifications or renovations of this building. It was done by the tenant, Ability Rehab, and they are here behind me to let you know it was them who are responsible for this, not Medical Building.
Okay. You're the property owner, so the violation is against the property owner, regardless of whether the tenant was the one to actually construct it. Did you have anything else you wanted to add?
No, the corporate office, it's a publicly traded company that rents the building. And I communicated with the corporate office last week when I received the certified letter in the mail, and they said they would take care of the situation since the local team was unable to.
Okay. Do you believe that 60 days will be sufficient for you to obtain the permits?
Ma'am, I would have thought it would have been done 6 months ago.
Okay. Yes. You're the tenant?
Yes.
Okay, briefly.
My name is Donna Sanciato. I am a managing partner of Ability Rehabilitation. This is George Burton, who is the contractor.
I'd like to speak to you, Your Honor.
Okay.
My name is George Burton, 1 Sunny Road, Ormond Beach, Florida. We are currently trying to pull these permits with the fire Marshall here did not disclose was those were rejected because they added additional comments on the second try. On the third try, we actually called the city of Deltona to wonder what was going on with our permit that we haven't heard nothing from, and we were told that it was by a Gale Dugal, that it was not uploaded correctly. So our revisions that were submitted were never looked at for over 2 months. They sat somewhere. In the meantime, the chief building official was removed and another one installed. I spoke with him on Monday, Chad Tate, and he said that he understood my situation but couldn't do anything for me at this time. Now, we resubmitted those on June 17th. I believe that would be the city of Deltona's responsibility. In fact, his permit that he is saying has been done is still hinging on a final inspection by the issuance of this permit. So most of this, it was delayed for several reasons. 2 of those meetings, the fire marshal was me and him meeting to go over things, not because they were delinquent. It was for clarification, to make sure the permit was pulled accordingly. So at this time, I say that the city of Deltona is the reason we're here tonight.
Okay. With regard to the time period, would the city be willing to extend that to 90 just to ensure that they have sufficient time? Because it sounds like there's been some delays.
Yes, we'll extend it to 90 days.
Okay. And I think that might give you some extra wiggle room there.
I'd like to add to that for the record, with the permit being issued, because that seems to be the only problem. We could wrap this up in 48 hours if we had the paperwork. But we'll take the 90 days with what we've got going on with the city with a new building official.
Right. That's and to correct the violation, you're going to have to actually get the permit. So I want to make sure that you have sufficient time to do that. So yes, I'm willing to give a little extra.
Thank you.
Okay. I'm going to go ahead and make my ruling. I find respondent in this case in violation of the city code as charged, in particular chapter NFPA 1, chapter 1.7.12.10, and that respondent correct the violation before 4:00 p.m. on November 26, 2024. So that's 90 days.
Yep.
In the event respondent does not comply by the state, fine in the amount of $50 per day will be imposed for each day the violation continues past the aforestated date. Respondent is further ordered to contact the code inspector to verify compliance with this order. I'm also admitting the case file in the PowerPoint, and I find the notices were properly given in this case. Thank you. Okay, the next case is DEL 24-085, A, B, and C for 55 Cortlandt Boulevard.
Good evening. My name is Bashir Turkzi. I am employed by the City of Deltona as a code compliance officer. This would be case number DEL 2485A, B, and C. City of Deltona versus Dollar Tree Stores, Inc. The property address is 55 Cortlandt Boulevard, Deltona, Florida 32738. Parcel ID number is 813-060-000-030. This property is being brought before the special magistrate for more than one violation. These violations are as follows. Violation A. This is a violation of City of Deltona Ordinance Section 18-5, adopting the latest edition of the International Property Maintenance Code, Section 304-2, which states that all exterior surfaces, including but not limited to doors, door and window frames, cornices, porches, trim, balconies, decks, and fences, shall be kept in sound working condition and maintained in good repair. The exterior wood surfaces other than decay-resistant woods shall be protected from the elements and decay by painting or other protective covering or treatment. Corrective action for said violation is to repair or replace damaged exterior surface. Application must be submitted to the City of Deltona, 2345 Providence Boulevard, Deltona, Florida 32725. The structure must meet all requirements of city ordinance and be approved on final inspection. Contact our office with the permit number when obtained. Violation B and C are for the same violation, no permit. Violation B is for canopy, and violation C is for mechanical permit. So I'm going to read the violation at the same time. This is a violation of City of Deltona Ordinance Section 18.3, adopting the latest edition of the Florida Building Code, Section 105.1, which states that any owner, authorized agent who intend to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause any such work to be done, shall first make application to the building official and obtain the required permit. Corrective action for said violations is to obtain a permit for both the canopy and the mechanical work. Applications must be submitted to the City of Deltona, 2345 Providence Boulevard, Deltona, Florida 32725. The structure must meet all requirements of city ordinance and be approved on final inspection. Contact our office with the permit number when obtained. The statutory requirements for notifications of this hearing have been met by the notice of hearing and a notice of code violation being sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. Violation A. This case was opened on July 8, 24, while I was addressing others in the corrective actions. I have also tried contacting the store's district manager and left a voicemail with no success. The notice of violation was also posted on April 30th, 24, and the property owner was given until May 10th to come into compliance. As of today, the property is still in violation.
Is May 10th for both B and C?
Correct.
Thank you.
The city would like to request 30 days for the property to come into compliance, or a fine of $50 per day per violation, a total of $150 per day to be imposed until such time that the property owner notifies the city of compliance.
Okay. Okay. I'll get with you in a moment. So can you explain the canopy? What's the canopy we're talking about?
The canopy, it's an outside canopy up. There's no picture, but it's, yeah, right there.
The green canopy?
Correct.
Above the door? Okay.
Yes, ma'am.
So that was installed without a permit?
It was installed with a permit, but both permits for both the canopy and the mechanical work have expired.
They've expired without them getting closed out?
Correct.
Okay. Okay, and what was the mechanical work?
The mechanical is for a refrigeration system, I think the coolers inside the store.
Meaning like coolers
refrigerators.
that customers go in and open, or?
I believe so, yes. So it says refrigeration on the permit.
Okay. Did you have anything else to add?
Nope.
Okay. Sir, can you state your name and address for the record?
Yes, may it please the court. My name is Austin Palambizio. I am local counsel for Dollar Tree and Family Dollar.
Okay.
My client, I'm just here to explain my client's position. First of all, we're not here to refute what this officer has to say or to disagree. I drove by the building myself, and I agree that it's still boarded up and in the condition as he shows it. To clear up the communication issues, I myself handle all the Family Dollar, Dollar Tree code enforcement problems on this side of the state, and as well as in the Tampa area. Sometimes it doesn't make it from the store level to the management level. That's kind of where I fill in and close the gap. I'd like to let this court know that my client has contracted with a company called True Source, and what they're waiting on is a notice of commencement notarized in the original document. That's what they need. I'm unaware if the permits have been issued or not. I know they're taking steps to apply for it if they haven't already.
No, they have.
They have?
No.
They have not? Okay.
Yeah.
I'll let them know.
So True Source is the contractor that's going to?
Yes, I believe so, yes. And I believe they will be applying for it.
Okay.
Since we have taken steps and incurred extra expenses to contract, and since we received the notice, they have taken steps to follow up. We request 60 days to come into compliance. I know the longest thing that we're going to have to endure is just the permitting. Once the permitting happens, it could be a 1-week job, and the actual repairs will be 1 day. So that's, that's all I have to say.
Okay. Is the city opposed to 60 days?
The city is okay with 60 days for the exterior walls, but the permit violation shouldn't need that much time. I think they should be able to address the expired permits within 30 days.
Well, it seems to me like that would be the one that would be most difficult to close. Yeah, I mean, because you're dealing with the contractor that's coming on board and having to submit the permit. So unless I'm inclined to give 60 days. So I'm going to go ahead and do that. Did you have anything else to add, either of you? All right. I'm going to go ahead and make the ruling. I find respondent in this case in violation of the city code as charged, and that respondent correct the violations before 4:00 p.m. so it's actually 61 days. That would be Monday, October 28th, 2024. And in the event respondent does not comply by the state, a fine in the amount of $50 for each violation, so $150 per day total, will be imposed for each day the violation continues past the aforestated date. Respondent is further ordered to contact the code inspector to verify compliance with this order, and I'm admitting the case file and the PowerPoint and finding the notices were properly given in this case. Thank you.
Thank you.
Thank you.
Okay. This would be case Fire 24-0047, 102 Lullwater Street.
For the record, my name is Lisa Nadeau. I am employed by the City of Deltona as a fire safety inspector. This will be case number Fire-047-2024, the City of Deltona versus 102 Lullwater LLC. The property address is 102 Lullwater Street, Deltona, Florida 32725. Parcel ID is 803-605-020010. This is a violation of the City of Deltona Ordinance, Chapter 42, Article 4, Fire Codes, Chapter 42-186, which adopts the most recent edition of the Florida Fire Prevention Code as adopted by the State Fire Marshal, which contains the Florida-specific version of NFPA 1, Chapter 13.6.1.2, fire extinguishers shall be provided where required by this code, as specified in Table 13.6.1.2, and the referenced codes and standards listed in Chapter 2. NFPA Chapter 1.7.12.10, no construction work shall proceed until the AHJ has reviewed the plans for compliance with the applicable codes and standards, and the applicable permits have been issued. NFPA 101, Chapter 31.3.4.5.1, in buildings other than those equipped throughout with an existing complete automatic smoke detection system, smoke alarms shall be installed in accordance with 9.6.2.10 as modified by 31.3.4.5.2 outside every sleeping area in the immediate vicinity of bedrooms and on all levels of the dwelling unit, including basements. NFPA 101, Chapter 7.1.6.4, walking surfaces and the means of egress shall be slip-resistant under foreseeable conditions. The violations of NFPA 1, Chapter 10.11.1.1, Chapter 10.11.1.6, Chapter 12.3.3.2, Florida Administrative Code 69A-60.0081, and Chapter 10.13.2.1, which are mentioned in the notice of violation, have been brought into compliance prior to this hearing. Corrective action for said violation is to provide fire extinguishers for the apartment building and laundry building, accessible within 75 feet of all points of the structure, tagged by a Florida licensed fire extinguisher dealer, repair the holes and splitting in the, that was taken care of, sorry. Obtain a permit for the installation of the window in the laundry room building, the installation of the new front door for Unit D, and the installation of a new front door for Unit C. Provide documentation that each dwelling unit is equipped with smoke alarms, provide slip resistant for stairs, exterior walking service. And that would be it. And statutory requirements would be the statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violations were sent certified mail to the property owner at the address listed at with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. On January 23, 2024, I conducted a fire safety inspection at this address where I observed the above-mentioned violations. I also observed a newly installed window inside of the laundry room building, and upon research, no permit was issued for the installation of this window. In addition, due to the fact that I was not able to access the individual units, it was requested that the property owner provide documentation that each unit is equipped with a portable fire extinguisher and smoke alarms. The property owner was notified in writing of the violations and given a time frame to correct said violations. Subsequent re-inspections on 5/24 of 2024, 7/3 of 2024, and 7/31 of 2024 found no progress on the violations. During the May 24, 2024 re-inspection, I also observed the front exterior door on Unit D had been replaced with no building permit issued. Additionally, on the July 3, 2024 re-inspection, it was observed that a new exterior door was also installed on Unit C with no permit issued. As of today, 8/28/2024, while conducting a site visit to verify no conditions had changed, I observed the following violations were brought into compliance. NFPA 1, Chapter 10.11.1.1, building address numbers had been installed on the front of the building. NFPA 1, Chapter 10.11.1.6, unit address identification letters had been installed. NFPA 1, Chapter 12.3.3.2, the laundry room ceiling repairs have been repaired. and the Florida Administrative Code 69A 60.0081, the trust sign R has been installed, and NFPA 1, Chapter 10.13.2.1, exterior vegetation has been removed, which are mentioned on the notice of violation has been brought into compliance prior to this hearing. However, no other violations had been corrected to date. We have received no documentation regarding the smoke alarms being installed or tested or fire extinguishers in the units. The city would like to request 45 days for the property to come into compliance, with the remainder of the violations are a fine of $50 per day for a maximum daily fine of $250 per day until the violations are brought into compliance and the property owner notifies the city of compliance.
Okay, thank you. All right, can I just walk through the remaining violations really quickly? So 13.6.1.2, that's the fire extinguishers have to be provided where required by this code.
Yes.
And specified in the table. Does the table, I did not review the table, so is the table basically because if it's a multifamily, or what does that provide?
It breaks it all down for assemblies, business occupants.
Okay. Based on the
apartment
occupancy?
buildings, yeah.
Okay, so you're saying based on this occupancy, which is what? Classified as what?
Commercial.
Okay. I'm sorry?
Its classification is apartment.
Classification is apartment, okay. All right, and so they have not provided evidence that fire extinguishers have been installed?
No, or
The
certified.
correct fire extinguishers, yeah.
I'll get to you in just a moment. Okay, so, and then we have 1.7.12.10, that's related to the doors, is that what you?
The doors and windows.
Doors and windows?
Yes.
Okay, how many doors? 2?
There's 2 apartment doors, yes.
And then how many windows were?
There's the front window in the laundry room, and then I believe he said today that the one on the side.
There's 2 windows, yeah.
2 windows?
Both of the windows in the building
Okay.
had been replaced.
All right, so you're saying there was no permit on file for that?
Yes, ma'am.
And then we have, let me make sure, 31.3.4.5.1. This is on the smoke alarms?
Yes, ma'am.
Okay. And have you inspected it? You're saying you have not inspected it to know whether or not they...
Right, we haven't gained access into the buildings themselves, but they are provided on their first email, which we didn't have an email for them at the time to send, but I did send him the smoke alarm inspection form today, so he can check all 4 apartments and write it down for us, that there
Okay.
are smoke alarms and they are functioning.
And that's an acceptable way of demonstrating to you that it's complied, is by filling out the form?
Yes, and they sign it and...
Okay.
Yeah.
And then the walking surfaces is where?
The stairwell.
Okay.
There's 2 apartments downstairs, 2 upstairs, so the stairs are on both sides and they lead up to the second floor, which is the 2 A and B, or B and C?
B and C.
B and C upstairs.
And so what is the walking surface now?
The stairs, it's just plain concrete. There's no slip resistance that's on it to prevent anybody from falling.
Okay. Are you able to provide him with the examples of what the acceptable materials would be? Have you already had that conversation?
We usually ask them to let us know what they're wanting, and then we usually review it.
Okay.
And see.
Okay, and I believe that's all of the remaining violations?
Yes, ma'am.
Okay. Sir, can you state your name and address for the record?
Scott McGrath, 210 Willow Bay Ridge Street, Sanford, Florida, 32771.
Okay, what would you like to tell me about the case?
The windows are going to be the biggest issue. I have to do some more research on that. A car hit the building in 2019, broke one of the windows, so we had them replaced. We used the general contractor. She was licensed and insured. She should have pulled those permits in 2019. So if they're not there, we may need to find a way to get that permitted. The door permits we've applied for, haven't heard anything on those for a while.
You did submit a permit application?
For the doors, not for the windows. The windows, like I said, that was done by a general contractor, 2019.
Okay. Does the city have any update on that? No? Okay. Did you have anything else to add?
No, I have some strips. They're 30 inches by, I think, 2 for the front of the steps. Is that acceptable?
I'd have to know what the...
They're like a black, I have them in the car.
So, Sharon, would that be okay, or the manufacturer's?
Yeah, Scott, if you just want to send us what it is that you want to install, we'll take a look at it and let you know if it's going to work or not. Yeah.
Okay. Do you believe 45 days to be sufficient for?
I think it will, other than maybe that window permit. That one worries me.
Okay. Would the city be willing to do 60 days on that one to give a little extra time?
Yeah, we're willing to do 60 days. That's new information to us about the building. So there may be more involved than just over-the-counter permits for windows.
Yeah, that one might be more difficult.
Yeah.
So 60 days for the window.
Yeah, we could do 60 days for the window. If we could do 45 still for the doors, those are over the counter. That's not a difficult task, but the one with the laundry room windows might be a little more challenging.
Okay, but actually that is one violation. So we'll just do 60.
Yeah.
Okay. Did you have anything else to add before I make the ruling? Okay. I'm going to find respondent in this case in violation of the city code as charged, and that respondent correct the violations before 4:00 p.m. Well, and let's be specific. So it's 45 days, which would actually it's 47 days due to the weekend. So it would be Monday, October 14th. And that would be for the violations of 13.6.1.2, 31.3.4.5.1, and 7.1.6.4. And then it would be 4:00 p.m. on 61 days, which would be October 28th. For the violation of 1.7.12.10, okay? In the event respondent does not comply by the state, a fine in the amount of $50 per day for each of those violations will be imposed. For each day the violation continues past the aforestated date, respondent is further ordered to contact the code inspector to verify compliance with this order. I'm going to omit the case file and the PowerPoint as an exhibit, and the notices were properly given in this case. Thank you.
There you
All right, this is case DEL 24-081, 1510 Howland Boulevard.
Evening.
Good evening.
My name is Nicholas Lopez. I'm employed by the City of Deltona as a code compliance officer. This will be case number DEL-24-081, the City of Deltona versus William Waldman. The property address is 1510 Howland Boulevard, Deltona, Florida 32738. The parcel ID number is 813-043-620-250. This is a violation of City of Deltona Ordinance Section 110-803, which states that principal and accessory structures and related projections, including driveways and swimming pool decks, shall not be erected in platted easements unless the easement has been abandoned/vacated consistent with sections 58-32 to 58-37 of the City Code of Ordinances. The corrective action for said violation is to remove principal, accessory structures, and related projections from the platted easement. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This was a reactive case. On July 9th, 2024, a shed was observed in the easement. A notice of violation was posted. As of today, August 28th, 2024, the property is still in violation with the shed remaining within the city easement. The city would like to request 30 days for the property to come into compliance or a fine of $100 per day to be imposed until such time that the property owner has notified the city of compliance. Also, prior to continuing, I do want to submit a survey into the exhibit.
Okay. And so you said this is a shed. It looks attached to
Yes, ma'am.
a home.
Correct. It is one big building with two overhangs on each side.
Okay.
Which were
you're saying it's a shed?
So it's a shed addition. That's what we're kind of considering it. That's
Shed addition?
Yes, that's in the city easement.
Okay.
Also, in the today photos, I went ahead on property appraiser and I highlighted the portion of the shed that's in the city easement just for a point of reference. Now, obviously, it's not to scale. That's why you have the survey there, so you can refer to that if necessary.
Okay, will you approach, and you can come forward too, if that's okay. Will you come down and stand there? Can you both of you come forward, because I just want to look at the survey with you.
Okay.
I just want to make sure I'm looking at it correctly. Is this the area right here? This is the apron.
It should be. I'm not certified to read the survey, so you're gonna have to get it from that.
Okay, maybe. Okay.
To the back of
That's it. Yeah. Right here is where I'm looking at.
That's correct. And actually, the roof is overhanging into the neighbor's property also, about maybe 9 to 10 inches.
Okay. Thank you. Where did the survey, how did the city obtain the survey? It looks like.
I could answer that. I guess the property owner applied for a shed permit, and that's what's highlighted on the survey, that he moved it from one section to another, and that was done in 2020.
Mm-hmm.
That's when we found that it was actually, that structure is in the easement, and actually the roof is overhanging into the neighbor's yard.
Okay, so the highlighted area is basically they're not related to this violation?
No, that was just a permit that was applied, and we have a survey to prove that
right.
it's an easement.
And I see there's a 10-foot public drainage and utility easement. Was that, is there, okay, so I'm seeing at the top of the boundary survey, it says that it is in Deltona Lakes, the Deltona Lakes plat. Is that correct?
Yes, ma'am.
All right. Okay. Did you have anything else to add?
No, ma'am.
And I'm sorry, I missed, you were recommending how much time to comply?
30 days for the property to come into compliance, or a fine of $100 per day to be imposed.
Of how much?
Of $100 per day.
100?
Yes, ma'am.
Okay. What's the reasoning for 100?
Just being that it's in the city easement. If we need to lower it, I'm fine with that.
Okay, understood. All right, sir, can you state your name and address for the record?
Yes, William Waldman, 1510 Howland Boulevard, Deltona, Florida.
Okay.
I don't know if I can jog your memory, but we were here about a month and a half ago.
Yes.
For this same structure, which they were saying I needed to obtain a permit because it was added on. And then it was determined that I didn't need a permit because it was built 30 years ago when the house was built.
Okay.
So it would have been approved and permitted when the house was built. So if it's in the easement, it should be grandfathered in because it was built and approved by the city, over 30 years ago. So that permit part got dismissed, and now all of a sudden we need to tear it down. But that goes, with a bunch of ongoing situations that I have with code enforcement. The last one being, Hurricane Debbie was in Jacksonville and we were still getting storms here. My security cameras show 2 fence panels blew down at 1:46 p.m. At 3:20, I had a violation on my door saying to fix my fence and to clean up my yard debris, which pom-poms were still falling from my trees due to the wind. That's ridiculous. And then
But we're not here for that violation.
Right, no, I'm just saying
Okay.
that's part of everything that's going on.
Okay.
So seeing I don't have to do the permit because it was already built, now there's another avenue they're trying to approach. And if you go, can you go back another picture, another one? Another one. There was one with a straight line right there. See where that fence is butt up against my existing building? That fence runs down there. That property there, my neighbor's property, is extra deep. There's my house, a neighbor's house, and then another neighbor's house. And that fence runs down the whole property, which means that whole fence would be in the easement, correct?
Well, I believe fences are permitted in the easement.
If permitted by the city. Yes, ma'am.
So it's really, I think what you're trying to asking me to find a violation of is not the fence, but the shed extension.
Yes, ma'am. There's a difference between fences and accessory structures, and the shed is considered an accessory structure, so it's a completely different entity from a fence. Or from a shed, excuse me.
Yeah.
Their neighbor's fence is actually attached to that building. and then it runs straight down, like I said, three properties. But if
Yeah.
the fence doesn't count, the fence doesn't count.
Yeah, it doesn't. I mean, section 110-803, which is what is cited here, subsection B provides the following improvements may be permitted in non-vacated or abandoned platted easements, which includes fences. So the fence could remain, at least according to the code.
Okay, but my point is, it was built with the house.
Yeah, so I recall that we were here before, and was the city able to determine or find the building permit that actually, that this was included in the original home? Is that?
No, ma'am. I mean, the furthest that we have is our property appraiser records, which they only go back so far. So at this point, I wouldn't be able to say definitively if that was there 30 years ago or not. But the fact still stands that the shed is in the easement. So that's what we're here for today.
Well, I mean, I'm concerned about this because what the respondent is bringing up is really indicative of estoppel arguments, essentially saying that, the city may have permitted this extension 30 years ago. And you don't really have any evidence to rebut that. And it's been there, and he's claiming it's been there for 30 years. So, I'm definitely concerned about the defense that's been raised. Mr. Ron, did you want to add something?
Yeah, after our last hearing, and we reached out to Volusia County, and there was no record of a permit for that structure. And from what we see, looks like that portion that's in the easement was added later from the kind of, you can see the two faded colors. I don't have the proof for it, but it's in the easement. The easement was never vacated for the structure to be there, and that's why we're here today.
Do you have records that go back 30 years of the building permits? Or is the city, they are well beyond the records retention period?
They're
So do you have them?
They're past the retention for our records, but we also reached out to Volusia County, and they could not find records on that either.
I'd like to add something. Does the resident have anything with them currently that can show that they've owned this property 30 plus years with them today that could be submitted?
It's not, as she stated at the beginning, it's the city's burden to show that it's in violation. And you don't have the records showing that it wasn't there.
Well, in this case, they have met their burden. They have shown that it's clearly in the easement. I think what you're trying to raise a defense, sir, which is your burden to prove a defense, right? But you've raised issues. You've said that it's been there for 30 years and that it was permitted as part of the original building.
Correct.
How do you know that?
Because I had to have, when I bought I could probably try and reach out to the people that did my title work when I bought it, because it had to be surveyed then. But that will show, I bought it 20 years ago, so it'll at least show that it was there 20 years ago.
All right. I hate to do this, but I'm inclined to continue this again to allow for you all to do the research that you need to do. So I think that's what I'm going to do. If you would like, sir, to do research to try to demonstrate that this was permitted, then I think that I need to consider an estoppel defense. So I'm going to do that. We'll continue this to the next hearing.
Okay.
Okay?
Okay, thank you.
All right.
Thank you.
All right, the next case is Fire 24-0035, the Massey case, 839 DeBerry Avenue.
Good evening. For the record, my name is Sharon Shivers. I'm employed by the City of Deltona as the fire marshal. This will be case number Fire-35-2024. The City of Deltona versus Coffin Richard H. Jr. TR-Trust-100%. Recon Trust-TR-Trust-100%. The property address is 839 DeBerry Avenue, Deltona 32725. Parcel ID 813-0520-40050. This is a Massey case. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall and on the property at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This was initially a case for a violation of the City of Deltona Ordinance, Chapter 42, Article 4, Fire Codes, Chapter 42-186, which adopts the most recent edition of the Florida Fire Prevention Code as adopted by the State Fire Marshal, which contains the Florida-specific versions of NFPA 1, Chapter 63.9.2.1, for other than vehicles equipped for and used compressed gas as a fuel for propelling the vehicle. An operational permit shall be An operational permit shall be required for liquid carbon dioxide systems in excess of 100 pounds of carbon dioxide. It was ruled on July 2nd, 2024, that the property owner was given 30 days to comply. The owner did not come into compliance within those 30 days and has been receiving a fine of $50 a day since August 3rd, 2024. No permits have been issued, and an operational permit has not been obtained as of today. The property has accrued a total of $1,300 over 26 days. In closing, the city is requesting that the fines continue at $50 per day until such property owner has notified the city of compliance and compliance is verified by a fire safety inspector.
Okay, you said no permits have been issued. Have they been applied for?
No, they have not.
Okay. I find respondent in this case failed to correct the violation by the time specified in special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code inspector. Respondent shall notify code inspector to verify compliance. Thank you.
Okay, thank you.
Okay, this is Fire 24-0041, 915 Doyle Road.
For the record, my name is Jory Bailey. I am an employee of the City of Deltona as a fire safety inspector. This will be case number fire 041-2024, the City of Deltona versus TCB Deltona LLC. The property address is 915 Doyle Road, Deltona, Florida 32725. Parcel ID is 910-609-000010. This is a violation of City of Deltona Ordinance, Chapter 42, Article 4, Fire Codes, Chapter 42-186, which adopts the most recent edition of the Florida Fire Prevention Code as adopted by the State Fire Marshal, NFPA 1, Chapter 13.3.3.4.3.4, as building systems, installation drawings, hydraulic calculations, original acceptance test records, and device manufacturer data sheets shall be retained for the life of the system, and NFPA 13/2019 edition, Chapter 1612.5.6, where a fire department connection serves only a portion of a building, a sign shall be attached indicating the portion of the building served. Corrective action for said violation is to contact your fire sprinkler service provider to provide a hydraulic calculation plate for the retail plaza portion of the Publix building. Provide signage for fire department connection directly in front of the FDCs for Building 100, Building 200, and Building 300. Durable signs shall be a minimum of 6 inches in height on contrasting backgrounds. Please ensure signage indicates Building 100, 200, 300 FDC on it, depending on which building it serves. Statutory requirements for notification of this hearing has been met by the notice of hearing and notice of code violations sent certified mail to the property owner at the address listed with the property appraiser record. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day that they were taken. On September 18, 2023, while conducting a fire safety inspection at property amongst other violations which has since been corrected, I observed the above-mentioned fire codes violations. The property owner was notified of the violations and the required corrective action. Subsequent inspections on December 11, 2023, February 23, 2024, April 2nd, 2024, found the violation still is unresolved. During April 2nd, 2024 inspection, it was noted that the FDC fire department connection signage has been installed. However, it still does not indicate the portion of the building that the FDC service. Follow-up inspections on June 4th, 2024 and July 12th, 2024 found the property still in violation. The city would like to request 30 days for the property to come into compliance or fine of $50 per violation per day for a total of $100 daily until such time that the property owner has notified the city compliance.
Okay. So for 16.12.5.6, there you're looking for
signage.
The signage. And you said that it has to have, because you had the sign, there were signs, but you're saying it has to have what exactly?
Which building or what portion of the building that the FDC is serving. So
Okay.
on this property, it is built in 3 parts, and each part has their own fire sprinkler system and their own backflow system. So they all So when you pull up to the property, you don't know which backflow system or which FDC system goes to which building.
Okay, so like on this one that we're showing on this picture right here, taken today, it would say like building 100 FDC?
Yes, or it'll say FDC and then building 100 will be right underneath it.
Okay, all right. And then for the 13.3.3.4.3.4, that would be, you're looking for the drawings or hydraulic calculations?
Yes, ma'am. It must be maintained for the life of the system. Yeah, if you go back one more. Yes, that sign right there is completely blank. There's no information on there whenever a sprinkler company.
All right, and so given that, do you believe 30 days would be sufficient then, if you're looking for records and so forth? Yes, okay. Okay. Anything else to add?
No.
Okay. I'm going to find respondent in this case in violation of the city code as charged.
One more thing. I don't know.
Yes.
I don't know if they're on virtually. If they was wanting to speak on behalf.
They're here virtually?
Did they get through? This is the 950.
We're having technical issues.
Okay.
We're trying to get them back on because they can't hear you at the moment. But we're trying to get the feed going.
Okay.
You should be good now. So they are on.
TCB Deltona LLC
is now joining.
Hello? Can the city hear us?
Yes.
Yes.
Did you hear the presentation?
We did not. Unfortunately, we did not hear any of it. My apologies.
All right, well, we're going to have to do it over again.
All right. All right.
Sorry about that.
All right, no problem. All right, for the record, my name is Jory Bailey. I am employed by the City of Deltona as a fire safety inspector. This will be the case number Fire 041-2024, the City of Deltona versus TCB Deltona LLC. The property address is 915 Doyle Road, Deltona, Florida 32725. Parcel ID is 910-609-000010. This is a violation of City of Deltona Ordinance, Chapter 42, Article 4, Fire Codes, Chapter 42-186, which adopts the most recent edition of the Florida Fire Prevention Code as adopted by the State Fire Marshal, NFPA 1, Chapter 13.3.3.4.3.4, as-built systems, installation drawings, hydraulic calculations, original acceptance test records, and device manufacturer's data sheets shall be retained for the life of the system, and NFPA 13 2019 edition, Chapter 16.12.5.6, where fire department connection service only a portion of a building, a sign shall be attached indicating the portion of the building served. Corrective action for said violation is to contact your fire sprinkler service provider to provide a hydraulic calculation plate for the retail plaza portion of the Publix building. Provides signage for fire department connection directly in front of the FDCs for building 100, building 200, building 300. Durable signage shall be a minimum of 6 inches in height on contrasting background. Please ensure signage indicates building 100, 200, 300 FDC on it, depending on which building it serves. Statutory requirements for notification of this hearing has been met by the notice of hearing and notice of code violations were sent certified mail to the property owner at the address listed with the property appraiser records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. On September 18, 2023, while conducting a fire safety inspection at the property, amongst other violations which has since been corrected, I observed the above-mentioned fire codes violations. The property owner was notified of the violations and required corrective action. Subsequent inspections on December 11, 2023, February 23, 2024, April 2nd, 2024, dollars daily until such time that the property owner has notified the city of compliance.
Thank you. And this is the special magistrate. I had previously asked about the signage and what was required. It was explained to me that the FDC sign has to say building 100 or 200 or 300 on it as applicable. And I asked about the possibility of obtaining hydraulic calculations if they were no longer available, how that would be achieved. And it was explained that that may be obtained through an engineer, correct? So those were the questions that I previously asked. Now for the respondent, will you please, do you intend to provide any testimony on this case?
We do, yes.
Okay, can you state your name and address for the record?
My name is Brad Archibald. I work for TCB Deltona. I'm a representative of the LLC.
Okay.
Our office is 353 North Clark Street, Suite 3625 in Chicago, Illinois.
Okay, what would you like to tell me about the case?
So I would just like to let everyone know that when we recently acquired the property from the previous owner, I believe Inspector Bailey informed us that there were violations in July. We contacted Wigington Fire, and we were advised that all violations were cleared. We notified Inspector Bailey and did not hear anything back from the reinspection in August. All these violations that are currently at the building were existing prior to our acquisition of the asset. We have the original drawings required for the backflow tags to be placed on the system, including the hydraulic calcs, have not been obtained, nor have they been found. We're doing our best to source these at the time, and we're exploring an option for an engineer to reverse calc the necessary information to get the plates remade. So we are asking for a 60-day extension to comply with the order.
Okay. For the city, are you amenable to 60 days for the violation on the hydraulic calculations?
This is Sharon Shivers, Fire Marshal, for the record. I would like to know, have you guys gotten any results back from the public records request that was submitted on August 19th?
Vic Mahata, who's also on the phone from our facilities team, we have not received anything back. At least I have not. I don't know, Vic, have you? Vic, you're on mute. I think it's safe to say that we have not heard back. Regarding the entire building, I believe there's only a record for the Publix portion, which is the grocery store.
Okay, and I also was just informed our Laserfish program has been down. We're moving to a cloud-based version, so that may add time to the public records request. So I am not opposed to doing the 60-day extension for compliance.
Okay, and...
Thank you. And just to confirm, we just need to add, the plates are actually out there. We just need to add the specific buildings. Is that correct? In addition to the backflow tags, those are the outstanding items?
Correct. The FDCs, they should be labeled Building 100 or Building 200 or Building 300, whichever portion that they serve.
I mean, it seems to me that could be done within the 30 days, so I want to be clear that the 60 days would only be with respect to the violation of 13.3.3.4.3.4. So, did you have anything else to add for the response?
I believe Vic is trying to speak, but I believe they need to unmute him.
I'm sorry, I did not understand what you said. Can you repeat that?
I believe Vic, who's on the phone right now, is attempting to speak.
Oh.
But they need to unmute him in order for him to speak.
Hey, can the city hear me now?
Yes.
Yes. Can you say your name and
thank
address
you.
for the record, please?
Sure. My first name is Vic, last name Mahadeo. I'm with the facilities management team for the property. Address is 301 South New York Avenue, Suite 200, Winter Park, Florida, 32789.
Okay, what would
And
you like
just
to
to
say?
kind of Yeah, sure. Just to kind of reiterate what Brad's been saying, we did submit the public records request. Our life safety vendor, Wigginton, has a relationship with the fire marshal. He has been in communication, and we have been following through in writing with Ms. Shivers as well as Inspector Bailey. Again, just a second, a 60-day timeline would be helpful. We did receive some information regarding the Publix Plaza, but again, with to Ms. Shivers' point, with the Laserfish system being down and us trying to source with prior ownership as well as the original developer as much time as we can be allowed just to get the proper drawings so we can properly identify the FDC and hydraulic calculations to get those signage installed, that would be greatly appreciated. But we are working on this tirelessly.
Yes, and I'm willing to provide the 60 days for the violation related to the hydraulic calculations. Anything else to add from the city or the respondent?
No, I'd like to just thank you for your time. As soon as we do get those drawings, this is a top priority for us to resolve, and we want to be, good stewards to the city. So thank you so much.
Yes, I appreciate that. I'm going to go ahead and make my ruling. I find respondent in this case in violation of the city code as charged, and that respondent correct the violation of chapter 16.12.5.6 within 30 days, which would be September 27th, 2024. And that respondent correct the violation of chapter 13.3.3.4.3.4 within, it's actually 61 days due to the weekend, so it's Monday, October 28th, 2024.
Thank you.
And
rest assured, once we get the information, we will be taking care of this immediately.
Okay, thanks. Let me finish my ruling. In the event respondent does not comply by the state, a fine in the amount of $50 per day will be imposed for each day each violation continues past the aforestated date, so there may be a total of $100 per day. The respondent is further ordered to contact the code inspector to verify compliance with this order, and I'm admitting the case file and the PowerPoint today as exhibits, and I find the notices were properly given in this case. Thank you.
Thank you.
Thank you.
TCB Deltona LLC.
Is now exiting.
Okay, the next case is DEL 24-071, a Massey case, 1986 Hunter Avenue.
My name is Nicholas Lopez. I'm employed by the City of Deltona as a code compliance officer. This will be Massey case number DEL 24-071, the City of Deltona versus Eric B. Sachs and Tamika L.T. Sachs. The property address is 1986 Hunter Ave, Deltona, Florida 32725. The parcel ID number is 813-015-060-100. The statutory requirements for notification of this hearing have been met by the notice of hearing.
Sorry, can you pause just a moment? You're saying there's a Zoom on this one?
It's supposed to be a Zoom.
Okay. So
The resident Tamika Sachs, this is going to be her case.
okay, all right. Sorry, please go ahead.
I'll go ahead and start over.
Yeah, thank you.
My name is Nicholas Lopez. I'm employed by the City of Deltona as a code compliance officer. This will be Massey case number DEL 24-071, the City of Deltona versus Eric B. Sachs and Tamika L.T. Sachs. The property address is 1986 Hunter Ave, Deltona, Florida 32725. The parcel ID number is 813-015-060-100. The statutory requirements for this notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This case was heard on July 2nd, 2024. The order was signed on August 1st, 2024, giving 31 days to come into compliance or a fine of $25 per day until the property came into compliance. The property is now 25 days in violation. The property has been in violation since August 4th, 2024 to the date of August 28th, 2024, today. A total of 25 days at $25 a day for a total fine of $625. Based on a testimony and evidence submitted in this case, the city is requesting that the magistrate impose the following. The fine continue until the property is in compliance.
Okay.
I'd like to make an additional statement.
Yes.
The young lady, Tamika Sachs, she is active duty in the United States Army, as you can see. Can't necessarily tell you what to do either way, but do want you to bear that in mind.
Okay, thank you. Give me just one moment. Okay, for the respondent, can you state your name and address for the record?
Mika Sachs, 1986 Hunter Avenue, Deltona, Florida 32725.
Thank you. What do you want to tell me about the case?
Okay. What Officer Lopez has said. My husband and I are active duty. We do occupy the residence, but after we got hit, Florida was hit with the two hurricanes back to back that caused the damage that is on our home. We were displaced after the second hurricane, which caused our home to be not livable at the moment, and so we were working with USAA. We've had property appraisers come out and look at the damage. USAA has been stating that they're going to give us the money to pay, and has like approved for it to happen, but every time they are supposed to cut the check or send us the check, they have stated that we need this document or this affidavit and such. So it's been a long delay. We have paid out of pocket so far to correct a lot of the other violations, and Officer Lopez has been gracious with, providing that time to do that. But the one thing that we have been back and forth with them about is providing the money for us to take care of the roof, which is the most current one in the soffit. They have not cut the check as of yet, and we are currently located or stationed in Kentucky. So it's either myself or my husband that has to take leave to come back and forth to take care of this. And we've also even tried to solicit family that's within the area. My dad is a retired Army veteran, so he definitely understands, and he's within the Polk City area. He's tried to help, even solicit help with contractors that weren't price gouging to help us. We have not had any luck as of now, currently, or in the past, we haven't had any luck. However, currently, I've recently talked with USAA. I've been updating Officer Lopez with what we've been going back and forth with. I recently got back in country. We were out of country in Europe within that time frame. So I'm just getting the notice and the fines and such, the certified mail. My husband and I have talked, and we are just going to have to pay out of pocket. We can't wait any longer for USAA to come to terms with what they're going to pay for and what they're not. The question that I have been going back and forth, or what's the issue, is because the hurricanes have hit back to back, those hurricanes that hit back to back, and then the hurricane most recent, it was last year, caused more damage. So the longer they wait, the more damage is going to happen, and we're in hurricane season again, and it's the constant back and forth. So my husband and I are going to end up paying out of pocket for the roof. We have contacted and we've made contact with Turkney roofing services. They're out of Jacksonville. I spoke with the contractor today. He wants to go inside the house to be able to look at the leaks and the damages and get into the attic to look at the soffit damage and such. So I told him that being that this is Labor Day coming up this weekend, I should be able to catch a flight there or get my father to meet him there to let him in the house to be able to look. He said I told him about the code violations. I told him, what we've been dealing with. He is willing to expedite and start the roofing services as long as we can get down there to meet him. So that is the plan now. I last spoke with him before getting on this court hearing. So that is where we are right now. Hopefully I can get there and meet him, or my father can meet him. Either way it goes, we're going to make it happen. We're tired of waiting for USAA, but I will still keep fighting it with USAA so that we can at least get our money back, because it's probably going to be over 20-something thousand, close to 30,000, which is what they quoted us at with the property appraiser when property adjuster quoted. So that's where we are. So we are definitely actively have been trying to get it completed.
Thank you.
But keep hitting the roadblocks.
Yes, I appreciate all that. Just to clarify, so in the pictures, you're showing an issue with the soffit.
Yes, ma'am.
Are we talking about that the violation will need to correct it will be to replace the whole roof, or just the hole in the soffit?
Just the hole in the soffit.
Yeah. So, because you're talking about, it sounds like you're talking about replacement of the entire roof with the USAA money at a $20,000 or $30,000 amount. Am I correct?
No, ma'am. It's what USAA, I was referring to what USAA property adjuster quoted.
Right.
They were stating that, to my understanding, to fix the hole in the soffit, the hole, because there are shingles missing and some holes right in that area where it's leaking, they're wanting to fix the hole and the roof together. So if I only have to fix just the hole in the soffit, when I speak to this roofing contractor again, I can just ask him to take care of that first and see if that will suffice, and then he can take care of the roof later. I can do that as well, whichever you want.
I mean, that's
whichever
what
way.
I'm trying to get at, is that it sounds to me like you may be able to just patch the hole in the soffit and then take care of the further roofing problems, later down the road. This is a Massey case, meaning that I had already imposed a date to comply, which was August 1st. And again, that's just related to the hole in the soffit, which could be probably much, easier, repaired a lot easier than replacing the whole roof. However, if the city's amenable, I'm willing to basically provide an extension, given that she's, in active service. And basically, if we can get the hole patched by, let's say, the end of next week or so, that we wouldn't impose the fines that have accrued so far. Is the city amenable to that? Because I think there's also been some, it sounds like, confusion about what exactly needed to be done to correct the violation, and it didn't involve, replacing the entire roof.
Yes, ma'am.
We have no problem with that, ma'am.
Okay. So that's what I'd like to do, is to say that we're not going to impose the fines that have accrued so far. However, to the extent I'm going to give until September 9th, which is a little over a week. If you can, and at that point, the fines, though, would begin to run at $25 a day if you don't get the roof, the soffit patched.
Okay.
Does that make sense?
Okay. Yes, ma'am.
Okay.
Yes, ma'am. Thank you so much. That is definitely the goal. Thank you. I appreciate it.
Ms. Sachs, if I may.
Yes, Officer Lopez.
My code compliance manager, Danny Ron, he did inform me that he would like to contact you, so be expecting that shortly, within the coming days.
Okay. Was it for something else, or?
For this case, ma'am.
Oh, okay. That works. Yes.
Okay, thank you.
Okay. You have her contact information, correct?
Yes, ma'am.
All right. All right. Was there anything else before I guess, make the formal ruling?
You're cutting out.
Okay. I think you're freezing a little bit. I'm going to make the ruling now, unless you have something else you need to add.
No, ma'am.
Okay. All right. So I'm going to find that respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case. However, the fine will not be imposed until September 9th. And at that point, if compliance has not been achieved, the fine will continue on at $25 per day. And then the fine will continue to run from September 9th until the property is brought into compliance and an affidavit of compliance has been filed by the code inspector. Respondent shall notify the code inspector to verify compliance. So please make sure you stay in contact with him to let him know when you've patched the hole.
Yes, ma'am.
Okay.
Thank you.
Thank you. I'm going to, for the record, also admit the case file, and I find that the notices were properly given in this case. Thank you.
Yes, ma'am. Thank you.
Thank you.
May I hang up?
Yes, you can hang up.
Thank you. Sorry. Have a good day.
All right, the next case is DEL 24-087, 1372 North Timber Crest Drive.
My name is Nicholas Lopez. I'm employed by the City of Deltona as a code compliance officer. This will be case number DEL-24-087, the City of Deltona versus Angela Barbieri. The property address is 1372 North Timber Crest Drive, Deltona, Florida 32738. The parcel ID number is 813-040-110010. This is a violation of City of Deltona Ordinance Section 66-19, subsection A5, which states that a mobile recreational shelters and vehicles, other camping type vehicles, excluding pickup covers, when appropriately mounted on a vehicle, boats, boat trailers, utility trailers, and other trailers, are permitted to be parked on any lot within the A, R1-R1 AAA, R1B, RE1, RE5, RM1, RM2, the single and two family residential areas of RPUD, MPUD, and the MH classifications, provided the following conditions are met. Such vehicles shall not be connected to water or sewer lines or be used for residential purposes. Corrective action for said violation is to cease use of the recreational vehicle for residential purposes and disconnect the vehicle from water and or sewage. The statutory requirements of notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals on what I observed on the day they were taken. This was a reactive case. According to City of Deltona Ordinance, Section 66-3, titled Definitions, vehicle means every device in, upon, or by which any person or property is or may be transported or drawn upon a highway, including trailers, tractors, campers, and recreational vehicles, and accepting devices exclusively upon stationary rails or tracks. On April 30th, 2024, a recreational vehicle was observed on the property being used as a place of living. A door hanger was left at the residence. Throughout the case, it must be noted that Ms. Barbieri provided FEMA documentation establishing a time frame for the RV to remain on the property until the end of July. After reviewing Florida State Statute 125.023 titled Temporary Shelter Prohibition, it has been established that the necessary requirements have not been fulfilled in totality for the RV to be used in continuance as a place of living. It must be stated that while making contact with Ms. Barbieri throughout the duration of this case, she consistently appeared to be lodging inside of the residence. As of today, August 28, 2024, the RV still remains on the property with no permits on file reflecting construction being done within the dwelling in an official capacity. Some additional notes I'd like you to bear in mind. Governor Ron DeSantis originally declared a state of emergency on September 23, 2022 for Hurricane Ian. City Ordinance 02-2023 enacted on January 17, 2023 allowed 2 consecutive 180-day periods with the possible addition of another 180-day extension, permitting the resident until July 10th, 2024 to have the RV. State statute only allows 36 months if all requirements have been met, which would give the resident until September 23rd, 2025. If you'd like to refer to state statute and city ordinance, it's going to be in Exhibit H under correspondence.
Okay. All right, walk me through the state statute. So this is, you're saying the 36 months would be until when?
If the 36 months was applicable to this case, then they would be extended until Tuesday, September 23rd, 2025. However, forgive me one moment. In subsections A, B, and C, it lists the requirements that must be met prior to that 36-month extension being granted.
Yeah.
And the reason why we're here today is because there haven't been any permits that are on file showing that there's current renovations being made on the house.
There are not.
Yes, ma'am.
There are not current building permits.
Not current building permits. She did get some permits previously done to have work done on the home, but there's nothing on file currently that can show us in an official capacity that there is work being done currently today.
Okay.
Also, she has, and it's listed in correspondence in Exhibit H, she does have invoices, receipts, et cetera, of things that they're doing right now to the home. However, according to state statute, we do need to have something on record within the municipality.
That you need to have a building permit.
Yes, ma'am. Building permit, plan or design,
Right.
or construction loan.
Right. All right, and the city ordinance you're saying is only allowed for extensions, possible extensions through when?
So,
July 10th?
bearing the city ordinance, or reflecting on the city ordinance, excuse me, she was only eligible until July 10th, 2024, which is now passed.
Yeah. And the compliance deadline, I think I saw, was August 17th, right?
On the notice of
On the
violation?
notice of violation.
One moment to confirm that.
The point being that there was some reasonable time given to
Yes, ma'am.
comply after July 10th.
Yes, ma'am.
All right. Did you have anything else to add?
No, ma'am.
Okay, and remind me, you said you're recommending what for the fine and compliance date?
The city would like to request 30 days for the property to come into compliance, or a fine of $100 per day to be imposed until such time that the property owner has notified the city of compliance.
Okay. And the means of coming into compliance would be either to, as you've put here, cease use of the recreational vehicle for residential purposes and disconnecting it from water and sewer, but another possibility would be to obtain building permits for any construction that's going on in the house, because at that point, she may fall under the state statute.
Yes, ma'am.
Okay.
Since state statute would supersede the city ordinance.
Okay. Did you have anything else to add there?
No, ma'am.
All right. For the respondent, can you state your name and address for the record?
My name is Angela Barbieri, and I live at 1372 North Timbercrest Drive, Deltona, Florida.
Okay, what would you like to...
32738.
Oh, thank you. What would you like to tell me about the case?
I would like to tell you that I am using the trailer to live in. My house is unsanitary and not able to be lived in. He may say I'm lodging in the house, but I have 2 dogs that I don't keep in a trailer, and I also have 2 kids. So he says lodging in the house, but that is what I've been told to do as well. I'm still supposed to be doing my laundry in the house. I don't have a washer or dryer in the trailer, but I do want to be sure that you, that the information about the state ordinance was something that I brought to Todd Mead's attention, and the 36 months is what I am hoping for to have compliance. I am an indigent person with no money. I'm a cancer patient. The city of Deltona's drainage plan into Lake Teresa is what failed, and my house became the city storm drain, so it continued to flood my house, and it was me that had to clean the storm drain in the middle of the hurricane, during Hurricane Ian, which happened on 9/28/22. The state ordinance says that I should have 36 months to repair my house, which it says it's not limited to building permits. If you can tell, I have had a building permit for a roof. I have had some plumbing done. I have had also some repairs made that do not require building permits. I have sent about 20 pages of emails to the city of different things, and they like to post notices with no ability to contact them. And I have also made a very good faith effort to repair damages that was indicated is over $27,000, not to mention a new drain field that already was replaced. I had water filling up my house. We cleaned the storm drain in the middle of the hurricane because the city of Deltona failed to do their job. My house became the city storm drain. I contacted and reached out to over 10 different organizations, with at least some of them having some available resources. I did get a new roof. Once they had the roof put in, they ruined every one of my ceilings, and I provided pictures to Nicholas Lopez yesterday per his request. I have contacted and reached out to all of these organizations, and I have a organization that I've also contacted, Lowe's. I've gotten estimates. I've asked if they will leave tile and flooring at the trash at the dumpster so that I can come pick it up. I believe that the state statute 125.023 allows me to reside in the temporary shelter that was placed on my property by the state of Florida, and the property until 9/23/25, which gives me until then to take care of the rest of the damage that is in my house that I can't fix myself, because I am the one that wants it fixed the most. I am the one. FEMA denied me. They gave me $1,500 for $30,000 worth of damage, and it's the city of Deltona that did not clean their storm drains. So with no financial ability, and you're going to charge another $100 a day for what I am making every good faith effort to provide every bit of information, which I have been in contact daily with the city of Deltona, but they have 5 days off during the week, so they don't respond, and they show up on Sunday mornings, and they know I'm not well, I'm not healthy, I am an unfit person, and I can't do these things myself, and like I said, I would be the first one that would be able to do these things.
Ma'am, do you need a minute to, I want to assure you I'm listening to you. I want to give you a moment if you need it. It's hard to understand. It's hard to understand.
I'm doing the best I can. I have everything wrote down, and I got off track because I don't understand why I am not within the 36 months of state ordinance 25. I'm sorry, the state ordinance that I brought to Todd Mead's attention, and Danny, who is above all this. I've been told that all of this is that they're trying to
to help me, and I don't know how the city is helping me.
All right, let's talk about that. So the statute says that you know, in order to enjoy this ability to live in the temporary shelter, or which includes a recreational vehicle, that you have to be making a good faith effort to rebuild or renovate, including but not limited to applying for a building permit. So can you please tell me what it is that you are working on in your home? And because the code enforcement officer has said there are no active building permits. So that's what I'm trying to understand. Can you please explain that?
And it says not limited to building permits, so I don't need building permits for flooring. I don't need building permits for painting. I don't need building permits for replacing walls that were destroyed in the hurricane because my house flooded. My house became the storm drain. My house took in everybody's raw sewage. My house took in everybody's oil and trash and everything that was in the streets and come into my house instead of go through the city drainage system that failed. Lake Teresa has its own issues. I have very limited money. I have no money. I have asked for help from all of these organizations. I have a company, a organization that is going to help me and part with me that is going to work on creating a additional plan of written out stuff that's going to give them all of the details. That is called recovery.
And you are right. It says that you can submit a plan or design to the city. So you're telling me that you are in the process of working on that plan?
I have already provided him with all of the details of things that we're fixing, we're doing ourselves right now. And I also have a company, it's called the Recovery Acceleration Fund. And they are going to, they had talked with me during January, and my son had emergency gallbladder surgery at age 12 in February. So things have been a little bit more of a unique situation than just being able to lay tile. I only have one hand that I can use to do things myself. I'm a cancer patient. I have more medical diagnosis than the alphabet times 3. So I'm definitely not healthy enough to be able to be doing the things myself. I'm doing the best I can, but I have complied with everything he's asked for, but him to say I'm lodging in the house, the state of Florida still owns the trailer. This is from the Florida Division of Emergency Management, and there is a possibility they're trying to gift I can't drive away with my Dodge Neon with a 40-foot handicap trailer. I can't take something that's not mine. I'll be going to jail for grand theft. It's not my trailer. I am still waiting for documentation that allows me to actually move it. The city of Deltona has come out and agreed that all of the electric and septic and everything is set up correctly, and only until 7/31 when the Unite program actually officially closed, but the NCS is not ending, and then they were given, Volusia County agreed that we can use the 36 months. I'm not the only case in Deltona that has a trailer on their property, and there are still trailers available from Unite. So I'm just trying to make sure that I'm doing everything I'm supposed to according to the 36 months from the certification date.
So for Mr. Lopez,
Yes, ma'am.
do you have, I believe what she's saying is that you already have a plan. If I'm understanding that correctly, you're saying the city you've already turned in a plan to the city. Is that correct?
I have sent him details as per his request of what we're working on and what still needs to be sent. I sent pictures. I sent him things that show him that it's not just two nickels rubbed together, that it's going to magically just fix the bathroom and remove the cabinets and remove the entire population of bugs that have come in with all the water. It's not safe.
I understand. So, Mr. Lopez, do you have a response to that?
Yes, ma'am. So she would need to apply for a permit with the city in regards to drywall at this point. I mean, she could do that. That's just a suggestion. I just spoke with my permitting tech, and she could apply for a permit as simple as that, and that would remedy the violation, at least for right now, and we would be able to extend that out per Florida State statute until September 25. What was the other part of your question? I'm sorry.
Well, so is drywall something you're going to be fixing for the respondent?
I have drywall. I have some drywall that does need to be replaced.
Yes.
I have a lot of different things that need to be replaced.
Okay. So did you hear Mr. Lopez? What he said is that if you submit for a building permit on that, then that would allow you to enjoy that Florida statute that you've cited. Yes, Mr. Ron?
The permit will cover 180 days.
Also,
once it's been issued.
Also, I'd like to add, I do want to state for the record, I am under oath. Throughout the entirety of the case, I've never seen Miss Barbieri inside of the RV. And as a matter of fact, when I went there today to take my photos for today, there was another gentleman who was inside of the RV appearing to be lodging in there. Can't say for sure, but it was only him. He wasn't her husband. It wasn't her daughter. And in correspondence, again, in Exhibit H, it lists the authorized users in the household. So that would be herself, the applicant, Angela Barbieri, Jet Hill, her son, and then Charlie Hill, her daughter. So I believe that this goes into detail about who's allowed in the RV, who's allowed to occupy it.
What are you citing to right now?
This is
the city's ordinance, or?
This is FDEM, Non-Congregate Shelter Program, the occupancy agreement, and it's in correspondence.
I see. Okay. Well, that may be an issue with regard to the agreement, I suppose, with, is it FDEM?
Yes, ma'am.
But, I mean, I'm not sure that that is relevant with regard to the statute.
Okay, I understand.
So, why, I mean, I'm still getting at is there a plan? Because what the statute says is that there is, the resident has to make a good faith effort to renovate, including but not limited to applying for a building permit or submitting a plan or design to the county or the city. So do you have, and what I'm asking is, has a written plan been submitted to you about what are the repairs that they're planning to make?
Not, well, one moment.
Let me kind of jump in. Todd Mead, Code Compliance Supervisor. Nick, in getting this case, I was brought in with following up and going through the documents with him, and Mrs. Angela did provide just her letter to try to get her case looked at. Not an official plan. A plan would be something that would show to the city that time frame she's going to be working on the house and getting things done. I showed the construction estimate, which is in letter she provided, but that was going to her FEMA. That was not an official plan submitted to get the work done. I talked to the building official. He saw within the construction estimate the plumbing area that was looking to be worked on. That's an area where she could apply for a permit, which would then get her back under Florida statute 125.0.
Or the drywall.
Or the drywall as well, but he saw the, so she has to, a plan would basically draw out a timeline of getting things repaired that would show us that there's official work to be done, plus the permit would still get her to that criteria that would allow her to continue to live until September of 2025, which is what we're looking for. We were looking for some type of plan to the end, or a permit that is open once the permit is
with
taken to
timelines
close.
is what you're saying.
So that's in the plan. That's how what we specify in a plan to receive a timeline of work to be done and completed to allow the residents to continue.
All right. All right. So for the respondent, did you hear that? I want to make sure you heard that.
Yes, and I can pull one of those myself, even though I don't do drywall, and the person that was here is someone that does drywall and is looking at giving estimates on my repairs and is a licensed and insured handyman person that does repairs. So just so you have that for record, that is someone that does repairs and is out helping with the things that need to be done with the house, so that you have that information.
Okay, I think, the requirements of the permit, they'll be able to walk you through that. So here's what I'm going to do. I'm going to find that a violation exists. However, as I've said in previous cases and this evening, I need to give a reasonable time to comply, so no fines will be imposed until the end of that time period that I give. And you can come into compliance by following the state statute that you have outlined. And what the city has explained is that in order to utilize that statute and come into compliance, you have basically the option of applying for one or more building permits, such as drywall or plumbing, or submitting a plan that has, construction timelines and lists of what you plan to do. And that will allow you to stay in the recreational vehicle. Does that make sense?
So at this time, I need a open permit that will satisfy the, not limited to having a building permit, but the records that they asked for that I provided may not have been in form letter, and I didn't send everything because he specifically asked me at my door not to send him a million things. And if he wants to see every single paper and every single organization that I have contacted to try to help, I have plenty of details of all of the things that I have done to make my good faith effort to rebuild and renovate the damaged permanent residential structure. And I was very blessed to be given a clean space for my kids and myself to live in during the construction, but I am unable to obtain a construction loan on my own. But I do have everything else that is there. But for the fine to be 30 days and then $100, that goes away if I can create a permit and deliver it to Todd Mead and Nick Lopez, and they can actually see that in their record and not come here and say that they can't see that because our system doesn't allow them to. Is that correct? I'll be able to provide that drywall or plumbing, and those are things that a homeowner can get themselves. So I can find out from the permitting department if I can get my own permit for those.
Yeah.
Okay.
The permitting department will be able to help you with obtaining the permit and what you need to do for that. I'm going to allow for 45 days instead of the 30 to give you a little extra time to obtain the permits or to work with Mr. Mead to submit a plan that is acceptable with the construction timelines. All right?
Okay, well, that sounds helpful, because tomorrow morning, tomorrow late afternoon, someone is coming here to reopen my options for the option to be able to obtain a business loan, since the city of Deltona didn't clean their storm drains, and now I have to have a lien on my house for 5 years because they did not do their job to clean the storm drain, and my house became the storm drain. But I will do what I can to comply, and I will go get a permit and go from there, if that is all it's going to take right now to be able to continue to renovate my house without having to disrupt my special needs children and take them somewhere else and have to try to figure out other things and other places to try to get them their bus and everything.
I appreciate that, and like I said, I'm giving you a little extra time to come into compliance. All right, I'm going to make my ruling now. I find respondent in this case in violation of the city code as charged, and that respondent correct the violation before 4:00 p.m. and it's actually 47 days because of the weekend, so it's Monday, October 14th.
Thank you.
Okay. In the event respondent does not comply by the state, a fine in the amount of, and I'm going to reduce it to 75. And a fine in the amount of $75 per day will be imposed for each day the violation continues past the aforestated date. Respondent is further ordered to contact the code inspector to verify compliance with this order. And we've already discussed the ways that you can come into compliance within that 45 days. All right?
Okay, thank you.
All right, thank you.
I appreciate it.
All right.
Thank you very much.
Bye-bye. All right. The next case is DEL 23-265, a Massey case, 801 Chippendale Street.
My name is Larry Sparling. I'm employed by the City of Deltona as a code compliance officer. This will be Massey case number DEL-23-265, the City of Deltona versus Misiel Garcia and Juritza Cortez. The property address is 801 Chippendale Street, Deltona, Florida 32725. Parcel ID number is 813-024-020-040. The statutory requirements for notification of this hearing has been met by the notice of hearing and notice of code violation sent, certified mail to the property owner's address listed with the property appraisers of record. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to Special Magistrate Clerk. I certify any and all photographs to be true and accurate portrayals that I observed on the day they were taken. It was ruled on November 29th, 23. The property owner was given 40 days to comply. The owner did not come into compliance within those 40 days and been receiving a fine of $25 a day since January 10th, 2024. As of today, the property has accrued a total fine of $5,775 over 231 days. The city is requesting that the fines continue at $25 per day until they come into compliance.
All right. And this was a case for a failure to obtain a permit for a newly constructed shed?
Correct.
Okay, and this is the picture of it, picture 2, where the wrapping is?
Yes.
Okay, thank you. And there still has no permit has been submitted at this time?
Right, they applied for the permit, but not.
They have applied?
They've applied.
Okay, but it hasn't been issued?
Not issued yet.
Okay. Is it just the application wasn't complete, or can you speak to that?
We needed more information on windows and doors. I guess that was submitted yesterday, and they're looking at getting it issued pretty shortly, I think.
All right. Did you have anything else to add?
Nope.
All right. Give me one moment. Okay. I find respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code inspector. Respondent shall notify code inspector to verify compliance, and I'm admitting the case file and PowerPoint and find the notices were properly given in this case. Thank you.
Thank you.
Okay, DEL 24-037 Massey, 815 Deltona Boulevard. Go ahead.
Okay. My name is Todd Bead. I'm employed by the City of Deltona as a code compliance officer. This will be Massey case number DEL 24037. The City of Deltona versus Circle K Stores Incorporated. The property address is 815 Deltona Boulevard, Deltona, Florida 32725. The parcel ID number is 813-022-380-020. The statutory requirements for notification of this hearing have been met by the notice of hearing and code violations sent certified mail to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, has been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. It was ruled on March 27th of 2024 that the property owner was given 47 days to comply. The owner did not come into compliance within those 47 days and has been receiving a fine of $25 a day since May 14th of 2024. As of today, the property has accrued a total fine of $2,675 over 107 days. The city is requesting that the fines continue at $25 per day. This was a case for basically a permit that expired and they to renew the permit. They did have representation at the Massey. They did submit for the permit. Permit has still been under review. Twice it's been sent back for resubmittals. Latest I think was in late May. Both the fire and the building have sent back and asking questions to the architect engineer on questions that have not been answered from them. So it's sitting not occupied or answered to complete the permitting process.
Okay, and then this was for these reheat ovens, the work that was done for the ovens?
Yeah. Yes.
Okay. Anything else?
No, that's
okay. I find the respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code inspector. Respondent shall notify the code inspector to verify compliance. Thank you. Oh, and I'm omitting the case file and PowerPoint, and notices were properly given in this case. Thank you.
Thank you. Thank you.
Just on that case, sorry, did you say that the fine was running for 107 days or 170?
107.
107. Thank you. All right, the next case is DEL 24-067, Massey, 1553 Providence Boulevard.
My name is Nicholas Lopez. I'm employed by the City of Deltona as a code compliance officer. It will be Massey case number DEL 24-067, the City of Deltona versus David S. Price, EST. The property address is 1553 Providence Boulevard, Deltona, Florida 32725. The parcel ID number is 813-055-06-0070. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This case was heard on July 2nd, 2024. The order was signed on August 1st, 2024, giving 31 days to come into compliance or a fine of $25 per day until the property comes into compliance. The property is now 25 days in violation. The property has been in violation since August 4th, 2024 to the date of August 28th, 2024, today. A total of 25 days at $25 a day for a total fine of $625. Based on the testimony and evidence submitted in this case, the city is requesting that the magistrate impose the following. The fine continue until property is in compliance.
Okay, so this was a case on accessory structures not being in good repair, and this is today's picture with the fence. Is it, so it's just a single panel, just unattached, right, that's standing?
Yes, ma'am. There's the single panel, which is missing pickets, and then there's, on the other side, the right side yard area of the property, there's just fence posts there without any paneling attached.
Okay. All right. I find that respondent in this case failed to correct the violation by the time specified in special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code inspector. Respondent shall notify the code inspector to verify compliance of admitting the case filed in PowerPoint and notices properly given in this case. The next case is DEL 24-072, Massey case, 2912, Thalita Terrace.
Good evening. My name is Bashir Turkzi. I'm employed by the City of Deltona as Code Compliance Officer. This will be Massey case number DEL 24-072. City of Deltona versus Thalita Terrace, LLC. The property address is 2912 Thalita Terrace, Deltona, Florida 32738. Parcel ID number is 8130-744-20270. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violations sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. It was ruled on July 2nd that the property owner was given 30 days to comply. The owner did not comply. The owner did not come into compliance within those 30 days and has been receiving a fine of $450 a day since August 2nd, 2024. As of today, the property has accrued a total fine of $12,150 over a period of 27 days. The city is requesting that the fines continue at $450 per day.
Okay, and this was for failing to have current building permits on all of the,
Correct. All 9 violations.
all 9 violations. And so they have not submitted any building permits?
Not as of today,
applications?
they haven't.
Okay. Anything else? Nope. Okay.
thank you.
I'm going to find that the respondent in this case failed to correct the violation by the time specified in special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code inspector. Respondent shall notify the code inspector to verify compliance. I'm admitting the case file and the PowerPoint as exhibits, and I find the notices properly given in this case.
Thank you.
Thank you. This is DEL 24-074, Massey case 2041 Swanson Drive.
My name is Nicholas Lopez. I'm employed by the City of Deltona as a code compliance officer. This will be Massey case number DEL 24-074, the City of Deltona versus Mandela K. Zabalunji, Hilda Akaya Corey, and Kawabena D. Corey. The property address is 2041 Swanson Drive, Deltona, Florida 32738. The parcel ID number is 813-017-210-040. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This case was heard on July 2nd, 2024. The order was signed on August 1st, 2024, giving 31 days to come into compliance or a fine of $25 per day until the property comes into compliance. The property is now 25 days in violation. The property has been in violation since August 4th, 2024 to the date of August 28th, 2024 today. A total of 25 days at $25 a day for a total fine of $625. Based on the testimony and evidence submitted in this case, the city is requesting that the magistrate impose the following. The fine continue until the property is in compliance.
Okay. This also was for an accessory structure not in good repair.
Yes, ma'am.
And is this a picture from today?
No, ma'am.
Oh, today. All right. So the fence is essentially falling down.
Yes, ma'am.
Okay. I find that respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that. Go ahead.
My name is Todd Mead. I'm employed by the City of Deltona as a code compliance officer. This will be Massey case number DEL 24075C. The City of Deltona versus Alfred Ellis and Marshall B. Ellis. The property address is 986 Sweetbriar Drive, Deltona, Florida 32725. The parcel ID number is 813-066-090-190. The statutory requirements for notification for this hearing have been met by the notice of hearing and notice of code violations sent certified mail to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. It was ruled on July 2nd of 2024 that the property owner was given 30 days to comply. The owner did not come into compliance within those 30 days and has been receiving a fine of $25 a day since August 2nd of 2024. As of today, the property has accrued a total fine of $675 over 27 days. As of 5:04 or 5:20 today, the homeowner has provided photos to me in the email to show the compliance of the violation. the photos were emailed to me prior to the magistrate case starting tonight. The homeowner has come into compliance for after the initial compliance date. The city would like to be noted to be noted as a repeat offender for the violation that has occurred on the violation, and we would like to at this time make it as no fine, no fees, but the repeat offender be noted for the case for any future occurrences of this violation to the property.
Okay, so you're saying he came into compliance before or after August 1st?
After.
Okay,
So
but
he did, when I went today to take the pictures, I explained to him, you're not in compliance, there's still fines been going. I told him, if you're coming to magistrate tonight, you can have up till 5:30 to prove your compliance. You can get compliance. So he provided those pictures to me. I do have them here on my phone if you'd like to look at them, that he's in compliance for the outdoor storage areas, which are on the side of the house, the stuff that he had on the driveway. So due to the fact that he's got other occurring violations, we're trying to work on that voluntary compliance. So we're asking to taking the reduction on his fines he's accrued now.
okay, so you're asking me not to impose the fines?
Correct.
Okay. Okay. But you're saying these photos are not the photos that he sent you that show?
No, the one he's just sent, I guess, opened the email before we started, and he'd sent them, so I do have them here. If you,
okay, would you like
which would be this side of the house we're in. Stuff today, the hot tub.
Okay. Yeah, you want to?
A wood structure he was putting, but it fell down, so it became more of a debris pile. There's two more.
Okay, that's the side yard.
You can see from the beginning of this case started, he had a lot of stuff going on the front and side.
Right.
He's cleaned them up pretty much.
Okay. All right. So all right, I will find then that the respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case. However, at the city's request, no fine will be imposed. And an affidavit of compliance will be filed.
Well, tomorrow morning.
All right.
To this afternoon or evening.
Okay. That will be, I think that's it for the ruling. And I'll admit the case file as well as the PowerPoint and the 3 photos that you just showed me into the record. And I find the notices were properly given in this case. Thank you. All right, the next case is DEL 24-080, 2880 Beckwith Street.
I'd like to make an amendment before we get started. On the notice of hearing, there was a typo that stated 2800 Beckwith. However, even on that same document, though, the violation address was correctly addressed as 2880. And my affidavit of posting is correct at 2880 Beckwith. Posted the notice of hearing on the garage door.
Okay, is this the certified mail receipt? This is the one for?
The certified mail didn't come directly to me, but when they send the certified mailings out, they use the property appraiser's page to do the mailing, and that's also included as 2880.
Right, well, I just want to make sure it was sent to 2880 rather than 2800. So the certified mailing receipt in here, it says notice of hearing. Is that, would this be for this? I guess that would be for this. Yes. Okay, I'm just making sure. All right, go ahead.
My name is Steve Brockhoff. I'm employed with the City of Deltona as a code compliance officer. This will be case number DEL 24-080, City of Deltona versus Anais Fabello and Myrta Esperon, if I may have not pronounced that correctly. Property address is 2880 Beckwith Street, Deltona, Florida. Parcel ID number is 813-034-350-070. This is a violation of City of Deltona Ordinance Section 66-18, subsection A, which states that no vehicle greater than 10,000 pounds manufacturer's gross vehicle weight or designed to carry 16 or more passengers or required a commercial driver's license of any endorsement to operate shall be parked, stored, or in a residential area or agricultural zoning district except in agricultural areas with lots of 5 acres or more. Statutory requirements for the notification of this hearing have been met by notices of hearing and the violation were sent certified mail to the property, to the owner of the property address listed to the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days before this hearing. All evidence in this case, including photographs, have been marked as exhibits and submitted to the code board clerk. I certify that the photographs be true and accurate portrayals of what I observed and the day they were taken. This case began on February 26, 2024, when I noticed a dump truck in the right-of-way in front of 2880 Beckwith and some damage to the recently repaved city road. I left a door hanger with a violation notice to correct. On March 10th, I noticed a violation, gave a slight extension. This time the vehicle was behind the house. On March 18th, I posted a notice of violation and requested certified mailing and time to correct being for March 27th. I didn't It's on the far north side of the city, so I don't get there on every day. And I did witness the violation occurring again on July 14th, and then also again on July 21st. On August 6th, then I posted notice of hearing for this 28th special magistrate. I was up there today, and the violation is not there. However, the staff requested the property be found in non-compliance at the time or after the posting date of compliance of the March 27th, and then be allowed to use it as a repeat violator if the violation occurs. Again, normally we would request $25 per day. If the violation occurs and the special magistrate agrees with it, then if it reoccurs within the next 5 years, we'd probably be requesting double that.
Right, okay. I'm going to, did you have anything else to add? Sorry.
No, ma'am.
All right, I'm going to find that, hang on, give me a second. Okay. I find that respondent in this case was in violation of the city code as charged and failed to correct the violation by the time specified for correction by the code enforcement officer, that the violation is now corrected and no fine be imposed currently. Any violation of the same code by respondent within 5 years from the date of this order shall be treated as a repeat violation for which a fine of up to $500 per day may be imposed.
Yeah, thank you.
Thank you, and I'll admit the case file and PowerPoint as exhibits, and I find the notices properly given in this case. Thank you.
Thank you.
All right, the next case is DEL 24-082, 887 Deltona Boulevard.
My name is Nicholas Lopez. I'm employed by the City of Deltona as a code compliance officer. This will be case number DEL-24-082, the City of Deltona versus Land Trust Service Corp. TR Trust number 887DB. The property address is 887 Deltona Boulevard, Deltona, Florida 32725. The parcel ID number is 803-604-010050. This is a violation of City of Deltona Ordinance Section 18-5, reference to 304.9, adopting the latest edition of the International Property Maintenance Code, which states all overhang extensions, including but not limited to canopies, marquees, signs, metal awnings, fire escapes, standpipes, and exhaust ducts shall be maintained in good repair and properly anchored so as to be kept in a sound condition. When required, all exposed surfaces of metal or wood shall be protected from the elements and against decay or rust by periodic application of weather coating material such as paint or similar surface treatment. Corrective action for said violation is to repair or replace the damaged sign. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed in the day they were taken. This was a reactive case. On July 8th, 2024, a sign was observed in disrepair at the property. A notice of violation was posted. As of today, August 28th, 2024, the property is still in violation with the sign remaining in disrepair. The city would like to request 30 days for the property to come into compliance or a fine of $50 per day to be imposed until such time that the property owner has notified the city of compliance.
Did you say 30 days and $50?
Yes, ma'am.
Okay. And then just to be clear about what exactly they would need to do to come into compliance, because there was quite a, so. All right. I find respondent in this case in violation of the city code as charged, and that respondent correct the violation before 4:00 p.m. on September 27th, which is 30 days. In the event respondent does not comply by the state, a fine in the amount of $50 per day will be imposed for each day the violation continues past the aforestated date. Respondent is further ordered to contact the code inspector to verify compliance with this order, and I'm admitting the case file and the PowerPoint as exhibits, and I find the notices properly given in this case. Thank you.
Thank you.
Okay, this is DEL 24-083. 631 Cloudcroft Drive. Go ahead.
My name is Janice Palasic, and I am employed by the City of Deltona as a Code Compliance Officer. This will be case number DEL 24-0083 A, B, and C. The City of Deltona versus Dwight Daniel. The property address is 631 Cloudcroft Drive. The parcel ID number is 813-042-130-190. This property is being brought before the special magistrate for more than one violation. These violations are as follows. Violation A. This is a violation of City of Deltona Ordinance Section 18-5, adopting the latest edition of the International Property Maintenance Code, Section 302.7, which states all accessory structures, including detached garages, fences, and walls, shall be maintained and kept in good repair and sound structural condition. Corrective action for said violation is repair or remove the shed. Violation B. This is a violation of the City of Deltona Ordinance Section 18-5, adopting the latest edition of the International Property Maintenance Code, Section 302.7, which states that all accessory structures, including detached garages, fences, and walls, shall be kept and maintained in good repair and sound structural condition. Corrective action for said violation is repair or remove the fence. Violation C. This is a violation of City of Deltona Ordinance Section 18-5, adopting the latest edition of the International Property Maintenance Code, Section 302.7, which states that all accessory structures, including detached garages, fences, and walls, shall be maintained and kept in good repair and sound structural condition. Corrective action for said violation is repair or remove the deck. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted onto the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day that they were taken. Violation A. This case was taken over from another officer and found to be run under the wrong violation. I reopened the case on May 2nd, 2024 for multiple violations. I observed a shed on the side of the home in disrepair. I posted a notice of violation onto the garage door. I then spoke to the resident of the home and explained the violation as well as the corrective action. I informed her that they would have 30 days to fix the violation. I made numerous attempts to speak with the residents after the 30-day compliance date was not met and the violations was not corrected. I posted a notice of hearing to the garage door on August 7th, 2024, as well as completed an affidavit of service. As of today, August 28th, 2024, the property is still not in compliance. Violation B. While addressing other violations on the property, I observed a fence in disrepair. I posted a notice of violation to the garage door. I again spoke with the resident of the home and explained to her the violation as well as the corrective action. I informed her that they would have 30 days to fix the violation. Again, I made numerous attempts to speak with the residents after the 30-day compliance date was not met and the violation was not corrected. I posted a notice of hearing to the garage door on August 7th, 2024, as well as completed an affidavit of service. As of today, August 28th, 2024, the property is still not in compliance. Violation C. While addressing other violations on the property, I observed a deck in disrepair. I posted the notice of violation to the garage door. Again, I spoke with the resident of the home and explained the violation as well as the corrective action and informed her that they would have 30 days to fix the violation. Again, I made numerous attempts to speak with the residents after the 30-day compliance date was not met and the violation was not corrected. I posted the notice of hearing to the garage door on August 7th, 2024, as well as completed an affidavit of service. As of today, August 28th, 2024, the property is still not in compliance. The city would like to request 30 days for the property to come into compliance or a fine of $25 per violation per day for a total of $75 total to be imposed until such a time that the property owner notifies the city of compliance.
Okay, thank you. The deck, is that like for maybe a above-ground pool or something?
Yeah, there may have been a pool there at one time, but there's pieces leaning. It's hard to see on one of the pictures. You could see that the one on the right is leaning forward, and there's pieces missing underneath it as well.
Okay.
And the fence is almost all down.
All right. I find respondent in this case in violation of the city code is charged, and that respondent correct the violation before 4:00 p.m. on September 27th, which is 30 days. In the event respondent does not comply by this date, a fine in the amount of $25 per day per violation, or $75 total, will be imposed for each day the violation continues past the aforestated date. Respondent is further ordered to contact the code inspector to verify compliance with this order. I'm admitting the case file and the PowerPoint as exhibits, and I find the notices properly given in this case. Thank you.
Thank you.
This is DEL 24-088, 2570 Coachman Drive. You had to wait for the very last one. You drew the short straw. All right, go ahead.
Hi, my name is Jeff Scott. I'm employed by the city of Deltona as a code compliance officer. This will be case number DEL 24088, the city of Deltona versus Fred Jones. Property address is 2570 Coachman Drive, Deltona, Florida 32738. Parcel ID is 813054. 06210. This is a violation of the City of Deltona Ordinance Section 6618H, restrictions on trucks and other vehicles, which states a maximum of 2 vehicles may be parked inside a rear yard. Corrective action for said violation is to reduce the number of vehicles to the maximum of 2 vehicles. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. This case was initiated as a complaint on July 5th, 2024 for too many vehicles on the property. I conducted a site visit and noticed multiple vehicles on the left side yard. I conducted a site visit again on 8/22 of 2024, and there were 3 vehicles on the left side yard. Site visit today of the hearing, and the property is now in compliance with 2 vehicles. The city would like to request this case to be set as a repeat violator for future violations of this ordinance, since it was still in violation after the initial compliance date of August 18th of 2024.
Okay, my only question is this the side yard? Is it a corner lot?
Yes, ma'am.
It's a corner, so that's why there's the sidewalk there?
Mhm.
Okay, thank you. All right. I find years from the date of this order shall be treated as a repeat violation for which a fine of up to $500 per day may be imposed.
Thank you, ma'am.
Thank you.
Yeah.
Okay. That is the last case. All right. Is there anything else, or can we adjourn? All right, we are adjourning. Thank you.